Hello everybody, welcome to the third part of Module A for the JAIIB PPB 2025 examination. When you talk about this series, we are conducting for the most important questions. This is the last part of Module A. If you have not seen the earlier two parts, it is highly recommended that you go and watch those videos as well. First of all, today we'll be covering the most important topics also because this is the last part, as I just told you, from Module A. So KYC norms is one of that topic where the CTD procedure is very important. What all OVDs are there in our particular banking system, or for that matter, for the KYC norms, satisfy the KYC norms, we have passport, driving license, for the proof of possession of Aadhaar number is there, then voter's ID card, and then job card issued by NREGA, and when we talk about the letter issued by the NPR, the National Population Register is also there. So what which of the document is not added here? PAN card. PAN card is not one of the OVD. Always remember. Updated address. If you have updated address, then utility bill which is not more than 2 months old must be submitted. Along with that, property or the municipal tax receipt must be there. After that, we have the pension or family pension payment as well as letter of allotment of that accommodation. So all these things you must carry if you want to have a particular address change in these particular OVDs. Okay, OVDs are very important. Then another topic which is important for the exam is central KYC. So central KYC record register, one of the important topic. Reason being that here certain informations are important. So banks are required to upload the CKYC regularly the KYC data here pertaining to all the individual accounts opened on or after 1st Jan 2017. After your 1st Jan 2017, all those documents of your account opening must be uploaded here. Banks are required to upload KYC records pertaining to the accounts of legal entities opened on or after 1st April 2021. So for legal entities, the threshold date is 1st April 2021. In case of accounts of individuals opened prior to January 1, 2017, and those of the legal entities opened on prior to 1st April 2021, the KYC records are to be uploaded on the CKYCR during the periodic updation. So periodic updation, whenever you are ongoing, you are having the particular periodic updation, then also you must upload the latest KYC record in the CKYCR, the registry. KYC information should be uploaded within 10 days of commencement of account based relationship with the customer. So whenever you have the account based relationship with the customer, there also you must be uploading the documents within 10 days. So 10 days is the threshold here. Bank should communicate KYC identifier to the customer also. One mail you will be receiving if you are the customer, that your CKYC number is this. Then we have if for establishing an account-based relationship, a customer submits KYC identifier to a bank with the explicit consent to download the records from CKYCR. So whenever the customer's consent is there, then only we can access the records from CKYC registry. Next, we have the KYC norms CAP. This is another important policy, customer acceptance policy, where you will come to know that whether a particular person or the customer is having some fictitious name, or for that matter, whether they have opened the account anonymously or not. So no account is opened in anonymous or fictitious or benami name. You must know the owner of the account. No account is opened where appropriate customer due diligence measures cannot be applied, either due to the non-cooperation of the customer or non-reliability of the documents. No transaction or account-based relationship is undertaken without following your CDD process. So CDD process is very important. That's the message here. Circumstances in which a customer is permitted to act on behalf of another person or entity is clearly spelled out. So all those circumstances must be clearly spelled out here to ensure that the identity of the customer does not match with any other person or entity whose name appears on the sanctions list for the terrorist finance activities circulated by RBI. So that must also be ensured. Then you have to verify the PAN obtained through the facility of issuing authority to verify the digital signature of the document also. Mandatory information is to be obtained periodically or for your updation as well. In case of joint accounts, CTD process must be ensured. Next, we talk about the CIP. So we have seen CAP, fine, customer acceptance policy. We have seen CKYCR. the CDD process. Now let's move on to the CIP. Here again, in the customer identification procedure, you will have some important pointers. Customer identification is required to be done in the following cases. What are these cases? While opening the account, establishing the account based relationship, then undertaking international transfer for non-account holders. So if you don't have any account, if a doubt arises about the authenticity of the existing customer, then again you should be going through the CIP. Selling any product, including third party product, loading, reloading, prepaid travel cards of value of over 50,000, then also you have to go with the CIP. Carrying out the transaction or service is the series of connected transaction valuing over 50,000 for walk-in customer. So अगर walk-in customer है, then we have to go with the 50,000 limit. When there is a doubt that the customer is deliberately, intentionally doing the transactions within the range of 50,000, then it must be considered as a suspicious transaction. For the CDD procedure for sole proprietorship firm, what all procedure must be done? So you must have the RC registration certificate or the license issued by the municipal authorities under the Shop Establishment Act. Sale and income tax return must also be there. CST, then certificate, register document issued by the sales tax, IEC, then complete income tax return and utility bills. After that, we have the partnership firm. In partnership firm, what all is required? Again, RC, partnership deed, permanent account number, as well as KYC documents. For trusts, you will be having the certificate of registration, trust deed, PAN, and the documents, all those documents which are required. Companies, again, the certificate of incorporation, memorandum or the article of association, PAN of the company, then beneficial owners we have for the company, all those particulars for those members, resolution of the board of directors and power of attorney also, then KYC documents as well. So when I talk about the beneficial owner, how you will identify that yes, this particular individual is the beneficial owner. Let's just talk about the company. In case of company, if that individual is holding more than 25% share in the capital or profit, then definitely they are the beneficial owner. Control rights, the appointing majority of directors or control management and the policy decision, then also you will be termed as a beneficial owner. In case of partnership registered firm, you have more than 15% of the share in capital or profit. For body of individuals, association of persons, unregistered partnership societies, trusts, more than 15% of the capital if you are with the holding, then you will be termed as the beneficial owner. For trust, again registered ones, you should have 15% or more in trust. Okay. Now let's see the questions based on the particular topics which we have studied. Based on the information provided by for the CKYCR, which of the following statement is incorrect? You have to tell me the incorrect ones. When we talk about the first statement, banks must upload the KYC information opened on or after the 1st January 2017. So what is the threshold date for the CKYCR? KYC information should be uploaded within 10 days of establishing the account-based relationship. KYC for the LEs opened on or before 1st April 2021 must be uploaded. Banks are not required to communicate KYC identified to the customer. That is incorrect. Fine, we have seen that banks must communicate it. So D is the right answer. Based on the criteria for identifying beneficial owners, consider the following statements. Four statements are given for the beneficial owners. First, for a company, the person with more than 25% share in the capital or profit is considered as beneficial owner, whether it is true or not. 25% in case of company. For registered partnership, individual with more than 15% share in capital or profit can be the beneficial owner. Registered trust, you have author, trustee, beneficiary with 15% or more. They will be considered as the beneficial owner. If company's beneficial owner cannot be determined based on the share or profit criteria, the individual holding senior managing position is considered as the beneficial owner. So the correct answer will be option C. That is all of the above. Always remember beneficial owner for company 25%, then registered partnership 15% share in capital, registered trust again 15%, and the beneficial owner for the company cannot be determined based on the share or profit criteria. That is also important to know. Then we have which of the following is true in respect of the CAP, customer acceptance policy. So whenever we study the acceptance policy, we say that no account should be opened in anonymous or fictitious or benami name. No account is opened where the appropriate customer due diligence measure cannot be applied, either due to non-cooperation of the customer or non-reliability of the documents or information furnished by the customer. The transaction or the account-based relationship is undertaken without following the CTT process, then also SCAP must be done. The circumstances in which customer is permitted to act on behalf of another person or entity is clearly spelled out, whether it is correct or not, clearly spelled out, to ensure that identity of the customer does not match with the any other person or entity whose name appears in the sanction list circulated by the RBI. So whenever we talk about the customer's identity, that must be having no name in the sanctions list. Verify the PAN obtained through various facility of the issuing authority. So D is the answer, that all of these are correct. Okay, so you must remember the CAP. Then we have CIP, customer identification process. Following statement not correct. So while opening the account or establishing account-based relationship, you must do the CIP process. Undertaking international transfer for non-account holder. If a doubt arises about authenticity of existing account, existing customer, adequacy or correctness of information about the customer, this is right or not. Selling any product, including third-party product. Loading, reloading of prepaid travel cards for value of over rupees 1 lakh. So 1 lakh and above, whether you have to go for the CIP or not. Carrying out transaction or series of connected transaction valuing over 80,000 for the walk-in customer, whether it is 50,000 or 80,000. Where there is doubt for the customer who is intentionally structuring the transactions below threshold of 80,000, then you should do the CIP. So yes, the correct answer is option C. 4, 5, and 6. All the three are incorrect statements. Rest three are correct, and you have to tell me the not correct statement. So C is the right answer here.